Nicholas Stephanopoulos and his colleague invented a metric, I can call it, or a method of quantifying how partisan a gerrymander is. It's called the efficiency gap. It's a way of ranking gerrymanders around the country as more or less partisan, redistricting schemes as more or less biased. Now, we used that very much in our case. It was a big part of the trial case because we felt, based on those earlier Supreme Court opinions I mentioned, where people had challenged partisan gerrymanders as unconstitutional, and the Supreme Court hadn't quite bit, so to speak. They hadn't yet established a principle. That one of their Supreme Court's concerns was, well, if we say that a districting scheme was unconstitutional because it's excessively partisan, how do we know how excessively partisan it is, and how can we be sure that the districting schemes that we're invalidating are the most extreme? In other words, we need some way of rank ordering them from most partisan to least, most biased to least biased, so, and then we can figure out where we want to draw the line. But we'd want to do it in some kind of rational way, which wasn't totally haphazard, so the Supreme Court could say it's the most partisan one, the most biased ones that are being thrown out. Well, Professor Stephanopoulos and a co-author came up with this method of ranking them, which I happen to think is a pretty reliable way. There are other ways to rank them. They're all more or less in agreement, not precisely, but the bottom line is they're pretty close in their rankings. Wisconsin's one of the worst by any method. But we bought on Stephanopoulos' one and used it as a big part of our case. And we thought it was going to be an important part of the Supreme Court decision. But because of the standing issue, they never really got there. But let me just say briefly what standing is. In order to bring a lawsuit, gets very technical. But if you're going to be a plaintiff, Hans and I are both plaintiffs, you have to say that you were adversely affected by whatever act you're complaining about. Here were the enactment of this districting. And the theory that we had before the last Supreme Court decision, which I think was still the best theory, that as all Democrats were victimized by this because of the way the legislature caucuses. So it was only necessary to establish that I was a Democrat. But what Justice Roberts said, and there was no precedent on this, but there is now, his decision, what he said in the June decision in Gill versus Whitford, he said, no, to have standing, you have to show that you're disadvantaged in the district in which you live. Well, I live in a packed district in Madison, but what we call a naturally packed district. That is to say, there's really no way to put me in a Republican district. If you know the geography of Madison at all, there's an isthmus between two lakes near the Capitol, and I live near there. It's highly Democratic, and if you wanted to put me in a Republican district, you'd have to draw the line right across the lake, a narrow line, and then go further up north, someplace, 40 miles. And then, so my district would be my house, and then it'd go across the lake and then up to someplace 40 miles away. That's the way you'd have to do it. Well, nobody'd ever do that. So he says I wasn't disadvantaged in the election of my own representative. So I didn't have standing. And they didn't have evidence about the other 11 plaintiffs we had at that time. But they're going to give us a chance to show we have plaintiffs who have standing. We've added 28 more. We got 40 now. We're quite confident some of them. We don't know what it means to be disadvantaged in the district in which you live. He didn't say what that means. You just have to show it. But we got 40, or actually about 34 different examples to show them. And I think if we can't convince them that we have some plaintiffs who are disadvantaged in the district when they vote, well, then it's an impossible standard to meet. So it doesn't, they might as well just say they're not going to put any limits on the case because nobody will satisfy standing. But they never really got to commenting on the efficiency gap for that reason.